You're welcome back, and of course we are live on X Spaces, on YouTube, on Facebook, and of course on myjoyonline.com. Your comments are welcome. We want to get interactive with you this afternoon. Let's settle with a matter that doesn't just want to go away anytime soon. Our former Member of Parliament on the ticket of the MPP for 2nd D, Andrew Ejapamesa, says the Judicial Services travel policy is absurd. Why? Because after the suspended Chief Justice was cited for paying per diem and buying plane tickets for her husband and daughter for holidays. Now, Gertrude Tokono, who has been suspended, insists she did no wrong and is backed by the former Deputy Energy Minister, Andrew Ejapamesa, says it does not make any sense that the state will fund family members to accompany the Chief Justice on official travel, make no such arrangement for holidays. He was speaking on the Super Morning Show.
I didn't hear you read in the policy that she can use that privilege on personal trips. I only heard you say official travel.
So the point I'm making is that the CJ on official travels, unlimited, and 2 vacations that the Judicial Service also put. No, it's in the document.
Can you read the part where it says 2 vacations? You have 2 minutes. 1 minute, actually.
Yeah, sure.
Yeah. I can bet my last point on this, that the Ejapamesa will not find what you told him to just look for. For the avoidance of doubt, I want to read to you the relevant portions of the travel policy of the Judicial Council. And this is paragraph B2. It says, where the Chief Justice embarks on a personal or private foreign travel, he or she shall be accompanied by the security alone. The security alone, if it is a private trip. If it is an official trip, she can go with 2 other persons of her choosing. And it can be a spouse and a child. Now, let's look at the response of the Chief Justice.
So, Sammy, go ahead.
He says, I'm reading the response and the admission, since the Ejapamesa is refusing to see. These are the words of the Chief Justice. I opted to utilize the authorization in paragraph 9 and paragraph 10 of the travel policy. What does paragraph 9 and paragraph 10 of the travel policy say? It is the privileges she has to travel with 2 people of her choosing on official travels. Now, she says that she utilized paragraph 9 and paragraph 10 of the travel policy to travel with my spouse and my daughter during my 2 holidays taken in September 2023. Need I say more? The 2 holidays were those holidays official trips? Oh, call vacation. What has that got to do with the state office? If you are sending your husband and your daughter on a vacation for holidays, why should we pay them per diem? Why should we buy them business class tickets? And you, Ejapamesa, you are defending this. Take your time and read the travel policy. Take your time. If you don't have a copy, I'm forwarding a copy to you now. Check your inbox and read it.
It's 10 o'clock.
So that's not defend the indispensable because of politics.
Mr. Mesa, have you found the relevant part you wanted to read?
So, paragraph B1 provides for 2 holidays for the Chief Justice in a year. Okay, with the Judicial Service, with travel expenses, hotel accommodation, and per diem to be borne by the Judicial Service, and capped at 14 days per round trip. So I'm saying that the Chief Justice is entitled to 2 holidays paid for by the Judicial Service every year.
But does it say
and she's
that
saying no? So I don't have the full complement of the document. And she provides the
and another person
the policy on travel documents by heads, okay, and says that she opted to do. But you see, Koyo, does it make sense? Okay, and I say this with a little bit of caution because I have not seen the full complement of the travel policy of the Judicial Service. It is only the extras that have been provided in the responses that I've seen. But I ask, does it make sense that if you are going on private travel, you can go with a security alone? security. But if you are going on official travel, you can go with your spouse and any third party of your choice.
Well, whether it makes sense or
no,
not.
So it's important.
That is what.
No, hold on. But the point I'm making is that it's important. Now look for the full complement of the document for us to look at. Let's think about it.
Yeah, but
how does it even make sense that when you are going on a private travel, that the expectation would be that you would ordinarily be traveling with your family? That one, the policy says you can go with the security person alone. How does that even make sense? Even without the benefit of the full document, and you haven't seen it.
No, hold on.
Take Samit Jemfi's word.
Hold on.
Right, so this was early on this morning on the Super Morning Show on Joy 99.7 FM. Now, there's a latest development to this matter. The Member of Parliament for Old Tafo in the Ashanti region, Vincent Ekwasafua, has this afternoon filed a fresh application at the Supreme Court seeking to quash the suspension of the Chief Justice. Now, this latest legal action follows President Mahama's recent decision to suspend the Chief Justice after a prima facie case was established in a petition calling for her removal. Earlier, the MP had challenged the President's authority to refer the petition to the Council of State for a prima facie determination. However, in view of this twist, Mr. Safua has returned to the Supreme Court with a fresh application aiming at suspending the President's directive. And that's what you have on the screens this afternoon, the details of it. And we'll be speaking to him shortly to tell us what exactly he's seeking to cure. Right, so let's go on the phone lines and bring in the Member of Parliament for Old Tafo in the Ashanti. He's also a private legal practitioner. Honorable Safo, good afternoon. Welcome to the program.
Yes.
Hello, Honorable.
Yeah, good afternoon.
Yes, good afternoon. And then I'm curious to know what exactly are you seeking to cure in this latest, suits regarding the Chief Justice?
Well, first and foremost, let me indicate that there is a pending application at the Supreme Court that was preceded by a declaration of certain relief that I sought for from the Supreme Court. So if you remember, on the 27th of March, I caused my lawyers to file at the Supreme Court asking for certain declarations. Those declarations borders on the fact that at every point in time, per my belief and understanding of Article 146 of the 1992 Constitution, the Chief Justice, if there's a trigger by way of a petition against him or her to remove her from office, even before any consultation whatsoever will have to be done by His Excellency the President, the Chief Justice ought to have been given a copy of the petition for her response and comments before any consultation whatsoever will be done.
Right.
Let me indicate that the petition or the said petition against the Chief Justice got to the office of the President somewhere in February. It is interesting to note that 6 clear weeks after the President of the Republic receiving that petition said nothing about the petition or even attempted to inform the Chief Justice, the person whose integrity, or if you like, the person that the petition borders about.
Right.
It took my application at the Supreme Court for the President to now serve a copy to the Chief Justice. So my point is that because there is a pending application seeking for an interlocutory injunction on the process, which process in my declarations when I triggered Article 2 and 130 of the 1992 Constitution, it is my belief that the whole process is now void and of no effect.
Even though the court has yet to pronounce on that.
That is my belief, and that is what I seek the court to declare. Now, His Excellency the President caused his spokesperson to issue to the Ghanaian public that he has established a prima facie case against the Chief Justice, and for that matter, he has triggered Article 146, 9 or 10 or so, and suspended the Chief Justice. It is my respective and considered opinion that because there is a substantive case, one, that is pending before the Supreme Court, and there is also an application, which application was seeking to stay the hands of the president to continue with the processes until the substantive case is heard and determined. The president couldn't have gone ahead to suspend the Chief Justice. Okay. This is hinged on the case of Mufat, that as soon as there is an application or whatsoever that is seeking to injunct or stay execution of a sort, that application, according to the Mufat case, should be seen as an application in itself, or if you like, an injunction in itself. It beats my imagination why the President of the Republic will go ahead to form a prima facie against the Chief Justice and also suspend the Chief Justice when there's a pending application and a case that is supposed to be heard. People will argue to you, or some people may say, that of course the President finally submitted, or if you like, ferried the petition to the Chief Justice to seek for her comments and responses. And for that matter, the case that is before the Supreme Court should be deemed as moot. Please, let me state again.
Right.
The doctrine of mootness does not affect constitutional matters, especially when it is deemed that there can be a reoccurrence of such matters. And the case in point, the J.H. Mensah case, in fact, last year, Kwame Bafo-Abonye sent a matter to the Supreme Court, and the Supreme Court had the occasion to reiterate the J.H. Mensah's point of case, that when there is a matter that has the propensity, the probability to reoccur, irrespective of the fact that reliefs that are sought in that injunction or that declarations that is sought at the Supreme Court may not be relevant anymore, the court has every responsibility to listen and determine the matter before any action whatsoever will have to be taken. And so it is on that basis that I have gone back to the Supreme Court, praying the Supreme Court to suspend the purported suspension of the Chief Justice of the Republic of Ghana. My brother, this seemed to be orchestrated.
Before we get into that, let me just go through the orders that you are seeking the courts to do. One, an order restraining any step or action from being purportedly taken as part of the processes for the removal of the Chief Justice under Article 146 or in any manner until the hearing and final determination of the instant action. Two, an order suspending the operation of the warrant for suspension of the Chief Justice purportedly issued by the President under Article 146(10) of the Constitution until the hearing and the final determination of the instant action, and any further order to this honorable court may seem to meet. The question on the minds of a lot of people is, and in all of these legal actions that are before the court, the President is only a conveyor belt as far as this particular matter is concerned. And the question people are asking, what wrong has the President done in exercising what the Constitution imposed on him?
The President, even before these petitions, and more importantly, even before he won elections, and after he won elections, by his actions and inactions, has been very clear that he has the support of his party to orchestrate against the removal of the Chief Justice. And for that matter, procedure or processes that has been outlined in the 1992 Constitution, precisely Article 146, is of no relevance to him. Why do I say so? His Excellency the President, even before 2024 December elections, and as part of my supplementary affidavit that I filed on Tuesday, I attached exhibits of same to indicate that indeed His Excellency the President is not coming to the table with an intention that he wants to do good to the Ghanaian people. He is not coming to the table with a mind and heart so clear to the Constitution of the Republic of Ghana, because he had cause to say on political platforms that when given the opportunity, he would change the Supreme Court bench.
I thought the word you used was that he will initiate move to reset the judiciary.
Absolutely. So he characterized the judiciary as a political judiciary. And that is the act that he is on now, is the path that he has taken now. We had cause to have the current chairman of the NDC, who is also a member of the Parliamentary Service Committee, to say that the Chief Justice and the Electoral Commission ought to resign themselves. And to him, if there is a removal of the Chief Justice and Electoral Commissioner, he will support it. This is something that I also attached to my supplementary affidavit last 2 days at the Supreme Court.
But that's
we've had Mustafa Gandhi, who is a deputy operations director at the presidency, also attacking the Chief Justice. And so my point is that the NDC and His Excellency John Dramani Mahama is not interested in due process. If you want to, and I submit, if you want to take off or remove a Chief Justice, because the judiciary is a bastion of our democracy, it is incumbent on us that whatever will be a cause to remove the Chief Justice should be deeply grave. But it should not be anything that, to me, can be frivolous, vexatious, things that are not deep enough, but because there is an anticipation or there is an orchestration that come what may, the Chief Justice must go.
But honorable,
anybody will go ahead with what is happening today.
But honorable Safwa, you are a lawyer and a member of Parliament as well. I mean, the political commentary we can accept that the government, the current administration may have issues with the structure of our judiciary and certain individuals appointed by the former president. They've been quite vocal on it. But in terms of the removal of the Chief Justice, the reason that somebody can petition for his or her removal is quite grounded in the Constitution, incompetent, stated, misconduct, and the rest. It is based on this that the president, based on the petition, referred it to the Council of the. Now we have been told out of the 31 membership, 30 ruled that the Chief Justice has a question to answer. And now we've also been told about the reason that appears to be what is before the 5-member committee that will go into this particular matter, including even the use of public funds for the procurement of air tickets and the payment of per diem to some family members and the likes. Clearly, all of this are what is before them. The political commentary doesn't come in at all.
My brother, no one is going on the tangent of political commentary. The point I'm trying to make is that if a Council of State that has been largely appointed by the current president, whose preoccupation, whose intent before elections and after elections with the support of his party has been to take off, or if you like, remove the Chief Justice. Why would I be surprised that the Council of State will support the president in forming a prima facie against the Chief Justice? Why would I? I will not be surprised. And so it is not a political commentary, but it is an orchestration that is clearly choreographed to remove the Chief Justice. And all well-meaning Ghanaians should be interested in this, because today it is Tokono. Tomorrow it will be someone else. Let it not be said that we want to live in a country, a democratic country for that matter, where every 4 years, or when there is a change of government, we will change the head of the judiciary. That cannot be our course. We have come a long way from 1992 till today. We cannot assault our democracy and our institutions of government this way.
And so this latest action essentially is asking the court to suspend the suspension of the Chief Justice.
Rightly so.
All right. Well, well, thank you so much for your time this afternoon. Of course, we'll follow through on this one. That is the latest from on the Chief Justice matter. A new lawsuit filed at the High Court by the Member of Parliament for Otafo, Vincent Ekwasafua, and is asking the court to issue an order that will restrain any step or action from being purportedly taken as part of the processes for the removal of the Chief Justice under Article 146 or any manner until the hearing and final determination of the instant action. Also seeking an order of the court suspending the operation of the warrant for suspension of the Chief Justice purportedly issued by President Mahama under Article 146(10) of the 1982 Constitution until the hearing and final determination of the instant justice, that is previous cases that are before the court, and any other orders at the court may deem fit. And this was, filed today at the High Court, and the lawyer representing him is Godfred Yeboadame, former Attorney General, and we'll keep an eye on this matter because we've not heard the last of this particular matter.